Hi, everybody. Adrian Fuentes here. Did you know that the Democrats of Greater Tucson has a website, thedgt.org, and if you subscribe, it's only 20 bucks. You can support this great weekly communication where folks get together. Sometimes there's candidates, sometimes folks like me pop on to help understand what's going on in the world. The Democrats of Greater Tucson, thedgt.org. Join up today.
So welcome everybody to this evening panel for Democrats of Greater Tucson. Today we're joined by Thomas Collins. He's the Executive Director of Arizona's Clean Elections, is responsible for and heads the board for the unique public campaign financing system that we have here in Arizona for our candidates. He's an attorney specializing in elections, appeals, and administrative law. He graduated from right down here at U Arizona College of Law, what some people still grudgingly call James E. Rogers College of Law. I guess that was $50 million well spent. Mr. Collins was an assistant attorney general for the Attorney General's office focused on election law and appeals and attorney general opinions. He also clerked for previous Justice Scott Bales, who retired from the Arizona Supreme Court not too long ago, and late Justice Michael Ryan, my almost namesake. So congratulations on those two clerkships, very prestigious, and welcome to Democrats of Greater Tucson. And thank you for joining us and spending an evening with us here to talk about clean elections and for foregoing the So Too live to do so. Appreciate it.
Oh no, thank you, Michael, and thanks for everybody who's here. I'm going to go ahead, I guess, and just share my screen because I know we got some stuff we want to try to make sure we get through. So hopefully I'll do this correctly.
Sure. Again, I'm going to remove myself from Spotlight, and there you go. It's just you and your screen.
This is the public premiere of our new graphics, which we're excited about. As you can see in the subtitle, one of the things that we wanted to talk about specifically tonight, especially given the setting and the timing, in a little bit of depth, was Proposition 211, which is the Voters' Right to Know Act that voters passed in 2022 with around 70% of the vote. And then we're going to hit on some voter education topics, just to try to highlight and update you all on what we're doing in that capacity. And then a quick discussion, if you'll indulge me, on our clean funding program, which, as Michael alluded to, has been at the core of our mission over the years, but is a program that has faced a number of challenges, and many of you are familiar with candidates who've run under it and the challenges that are involved in that. So let's just start with Prop 211, and let's start with the big picture. One of the things that's been interesting about the law since it's passed is, and one of the reasons I was eager to have the opportunity to speak with you all is, we haven't gotten too much interaction between the commissioners, myself and other staff members, and the what I would call the political community, broadly speaking. So we hear from lawyers formally through formal channels. We don't hear from a lot of folks who are in the field yet, and we're hoping that will hopefully happen. When the Clean Elections Act was being implemented 25 years ago, there was more public participation than we're experiencing now. So, and that may be on. I think that's probably a little bit, if not a lot, on me to sort of make sure that we're out there talking about things to folks. So the big picture, and we're going to talk about what these words mean in a minute, but the big picture is this is an act that applies to people who make large campaign media spends. And we'll talk about what large means in a second. And and those folks who are covered by it, that's a term of art, covered person, which we'll talk about. they have to disclose the original source of funds. So, that's sort of the backdrop for everything we're going to talk about here in this segment. And obviously, as you have questions, put them in the chat. If I missed them, please tell me, or I don't know. But I think it's important to start to unpack some of that. I think that some of you who have been involved in campaigns in the past, especially if you've been a treasurer or a compliance person or anything associated with that, are going to find that some of these terms, as we go through them, are more familiar than you may initially think. So the first thing I suggest to folks, and this is even if you're a non-lawyer, for an act like Prop 211, you really want to start with the definition section. And the reason why I say that is because our campaign finance code, both in the Title 16, Chapter 6, Article 1, which is the regular campaign finance code, Chapter 6, Article 2, which is the Clean Elections Act, and then Chapter 6.1, which is the Voters' Right to Know Act. Each of those sections has a very lengthy definition section. And what that is telling you as a person is basically any term, as you're reading an act like that, that seems loaded, right? Seems like it's carrying a great weight. It's probably because it's a defined term. And you'll find that most of Prop 211, you really have to keep going back to the definitions to make sure that you understand where you're at in the act. And this is true for reading any law, really, but as a practical matter, it's decipherable. I think it's, I've read a lot of different drafts of a lot of different bills over the years. I think this one's pretty clear, but it is complicated. And it's complicated in part because all those terms are defined. It does. There we talk about that's where we define what a covered person is, and we'll have more about this in a minute. But basically, the covered person is the end spender. That's the person who is actually doing the IE or the ad for the ballot measure. It also defines campaign media spending, and that's really going to be an important thing to talk about because that's telling us what activities are going to trigger the next bullet point, the disclosure requirements. So basically, if you're thinking about this act, the first question you're going to always want to ask yourself is, am I a covered person? I'm going to determine if I'm a covered person based on my activities. That is to say, whether or not I'm doing campaign media spending at a threshold. And then, from that are going to be my disclosure obligations. So that's kind of how I suggest people try to think through it. And as you're thinking about it, or if you're, for example, if you're in a compliance position and you have an attorney or whatever, it's also helpful to do that because what you're doing there, if you can sort of start to think about this yourself, is you're going to save yourself some money with your attorney by trying to be a little more focused in your questions, I think. And that's just a kind of practice pointer. Those of you who do any kind of compliance stuff have the relationships you have, but I just know that the costs are always a concern. When we talk about these disclosure reports and exceptions, basically, there's a section on what's got to be in there, which we'll talk about. There are exceptions for certain circumstances. For example, if you have if there's a law that says that you're the kind of person whose identity ought not be revealed publicly, there's an exception for that. There's an exception that allows you to petition the commission if you feel like if you have reason to believe that you might face some harm from your disclosure as a donor. And then there's this thing called opt-out notices. And what that basically means is that donors need to receive an opt-out notice from the covered person before their dollars can be used for campaign media spending. So what that's designed to do, at least if you, in the view of the folks who put this together, is to give the donor a modicum of control over how their dollars are going to be used. So, this is what I've described as the guts of the act. Who's a covered person? So, a covered person is basically a person whose campaign media spending is more than $50,000 on a statewide campaign and more than $25,000 on any other kind of campaign. So now $25,000. So it doesn't, this is not like, unlike the Clean Elections Act, this is not narrowly drawn, it's narrowly tailored, but it's not narrowly drawn to legislative campaigns. The Prop 211 applies to city campaigns. It applies to, in theory, in theory, it applies to every election. Whether or not any of those elections will hit $25,000 is, is a question, and it's quite likely that not very many campaigns are going to hit a $25,000 threshold, right? Because even in most legislative races, with the exception of a handful of competitive districts in the Phoenix metro area, a $25,000 IE is a huge IE in a legislative race. Still, I mean, I know things are expensive, but now, importantly, who's not a covered person? So who can, when they're analyzing their situation, just take themselves out of Prop 211? Individuals will spend their own personal money. So basically, if I go buy an ad and says and I spend $100,000 on it personally, I'm not covered. I'm not going to have to file those disclosure reports. Organizations that spend only their own business income for campaign media spending. So this is sort of the conception that really kind of predates, or maybe dates around when Citizens United was first decided, which is, the idea was somehow that Target or Coca-Cola was just going to spend money on campaigns, which they could not in federal campaigns prior to Citizens United. So they're not going to be covered because there's no original source to disclose. They are in fact the source of their own income. We have not yet, seen that come up. So we don't yet know precisely what folks are going to try to characterize as their business income, but that's going to be a question. Another group entity that's accepted is candidate committees. And this is very important because, we want to be clear, candidates are already doing all kinds of disclosure through their PAC reports. And the focus of this is, in the words of the folks who framed the initiative for the voters, is about dark money. Well, most money to candidates is not dark money. It can't, at least in Arizona, it cannot be, because we have a ban still, fingers crossed, on direct corporate donations to candidates. And that would be the easiest way to facilitate getting, anonymous or dark money donations to candidates, which would raise a whole bunch of corruption issues that, obviously the commission is concerned about. And then a political action committee or a political party that doesn't receive more than $20,000 in contributions from any one person. So again, what is that telling us? That the PACs and political parties who might have additional reporting have to be at a higher threshold than just existing, right? They've got to be entities theoretically of a certain amount of size. I was going to continue here unless there's questions on that stuff there.
I know that there's been some confusion and consternation by treasurers on this point, that they were feeling that just about any money that was spent by the political party, they would have to reveal the ultimate source of it. But what I'm hearing is that campaign committees and political parties only have to disclose those that are more than $20,000.
To qualify as a covered person, they have to have, if I can figure out, I'm not sure I can go back easily. Maybe I can go back. Here we go. Oops.
Yeah, I know a couple of treasurers have been tearing their hair out thinking that they're going to have to.
All right. Well, let me go back one slide because I want to talk about that a little more. Okay, so it's a political action committee that receives not more than $20,000 in contributions from any one person.
Yeah.
So if you're a PAC that receives, that's just a regular PAC that doesn't have a big contribution, like a $20,000 type contribution, your disclosure obligations are going to be those that are already set forth in Title 16.
Yeah.
So again, the idea here is the additional burden, to use the legal term, is proportional to the amount of money you have in play and how aggressively you're therefore seeking to influence the vote.
Okay, so just as a hypothetical, say I get 25, I'm a PAC and I receive $25,000 from one individual and $100 from a whole bunch of others. I only have to disclose the $25,000 one?
That's for a couple of different reasons, which we'll get into. But one, you only have to receive the $25,000. You need the original source of the $25,000. So if you got it from, if ABC PAC got it from DEF for America,
yeah,
ABC PAC would have to ask DEF for America who are your sources, and then those should be disclosed. The $100 donors are never going to be disclosed.
Yeah.
Because, and as we'll talk about a little bit later, the thresholds for disclosure are above $5,000.
Yeah.
So again, that's part of, to use the legal policy, that's part of the tailoring of this to be focused on a specific set of folks rather than increasing the overall reporting for everybody. So yeah, and I would urge, and I would just say this because and we say it all the time, if treasurers in particular have questions for us, we like to be and fashion ourselves to be pretty available as staff members, and so we're definitely interested in if we, and at a minimum, if we can provide you a straightforward yes or no answer, we'd like to do that. If we can't do that, we'll try to do something along those lines. The other thing we have that we had a more informal process for on the clean election side is we take advisory opinions requests, which have been a little bit helpful with some of the more fact specific questions that may not have a yes or no answer. It allows the commission to actually sort of take a hypothetical, and assess it like the FEC does. Does that kind of? I know it's a long answer to your question, Michael.
Do you have any of those advisory opinions on your website right now?
We do, and we'll get to that link here at the soon. But yes, there so far there've been 3, and they are on our website on our rulemaking page.
Great.
Chris has a question.
I wondered on the last bullet point, you were just talking about $20,000 in contributions.
Yeah.
This is where I get hooked up sometimes, not from any one person. So first of all, as long as it's not over 20,000 from any individual, you could have 5 individuals up to 20,000, right? That's first of all what that means, right?
Yes.
Okay. Second question though, you mentioned DEF organization. Does it mean person and or organization that you would get that from, or is it just a person? Does that matter?
No, it's not an individual. It's any entity. Person in this case would, yes, good question. In this case would mean an entity.
Okay. But it could be a person or it could be an entity.
Correct. Absolutely. It could be a natural person. Yes.
You mentioned the organization that can spend their own business income.
Yeah.
They're not covered. So that's like you said, Coca-Cola. If Coca-Cola puts their name out there that they're spending, then is it or is it not to be disclosed? It doesn't matter.
The theory, that's a good question. So the question was basically if a corporation like Coca-Cola, puts money into a campaign or does spending on I shouldn't say puts money, spends money on a campaign, why would they not be a covered person? They might have other reports that they have to file as a spender under Title 16. There in both the Clean Elections Act and the regular code, there are requirements that for spending reports for independent expenditures or for ballot measure advertising, right? Those have different thresholds. On those reports, all you're disclosing is that you are a person, you're an organization, and you spent the money and when you spent it. You're not providing any donors. You're not going to provide the business incomes donor because the business income is earned and owned by the spender. That's so in other words, there's nothing to be disclosed under the act because Coca-Cola earned that money through sales. And that's all in there. And this presentation does not get to this level of detail, but everything I've just said is actually defined. Like business income itself is defined. And, and so, yeah. So basically what the act is trying to say is, if we know it's a bona fide, exchange for goods and services that the entity that made that transaction wants to put into political spending, there's nothing more for the voters to know. It's their money, they earned it, they can spend it, and there's nothing else to ask them under the act. Does that sort of answer
Yeah,
that question?
sure. And they don't have to disclose it either if they don't want to, right?
Well, that's not necessarily true. There are these spending reports that don't get into donors that are required outside of Prop 211 that they might have to. It depends.
Okay.
So,
Thank you.
no, thank
Prop
you.
211 is not going to prompt them to do anything additional.
I'm sorry?
But Prop 211 isn't going to prompt them to need to do anything additional.
Right. That's right. So I want to talk a little bit about campaign media spending. And this is, and you'll have this, and I have I can send you I had to fix one typo in the version I sent you, Michael, but I'm happy to have people have this if they want it.
Yeah, please do.
Because this is kind of a laundry list, is all from the statute, and I don't expect anybody to be able to commit it to memory. But why I put all these things out here is because what I want to illustrate here is that most of these activities are activities that are already subject to some report. This might change the nature of the report. So if you fall into if you're spending $100,000 or $1 million on a statewide race, right? And you are, if you were a 501c4 doing $1 million in spending in a statewide election in 2022, you are not going to have to disclose your donors. That was the law. That's no longer the case, right? Those folks are going to have to disclose their donors, but the things that they're going to do that are going to require them to disclose their donors are things that are familiar to probably many of you who spent time with, with the campaign finance code, either at the federal level or at the state level. A public communication expressly advocating for or against the nomination or election of a candidate. That's sort of that's the definition of, right? That's the vote for so-and-so. Doesn't have to be magic words. I have to caution you, but basically that's that. Public, we also have a provision there that comes directly out of the original Clean Elections Act, a public communication that refers to a clearly identified candidate before the primary election, 90 days before the primary election. That's also basically the FEC electioneering standard, right? These sort of terms and the activities you'll do under these that might trigger a report, again, at those high thresholds or comparatively high thresholds, are things that campaigns do. Where it gets a little tricky, and we do have a pending AO request about some of these issues right now that is on our website that people are welcome to look at, if you look at the I think the second to the last bullet point, an activity or public communication supports the election or defeats of a candidate of an identified political party or the electoral prospects of an identified political party, including partisan voter registration, partisan get out the vote activity, or other partisan campaign activity. So this is we've dealt a little bit, and we'll talk a little bit more about what we've dealt with in the advisory opinion context, but this one's a little bit different than some of the other definitions because it's getting at what in common, what you all, when you say grassroots, this is what I think this is talking about.
Yeah, the other partisan campaign activity seems like a rather broad catch-all.
Right. So yeah, and so we're working to try to provide on that particular question what the best guidance we can on that, and hopefully we'll be able to work through some of that through the advisory opinion process. We know at a minimum that most of the stuff that we're talking about, we kind of know what it is. We also know it's got to be partisan, and then we'll see if we go to the next one. Well, I'd go through the public communication definition that's there, but I do want to get to the next slide, which is what's not campaign media spending. And there we've got, again, what I think of as very common campaign finance exceptions: news stories, commentary, editorials, you know, blog for Arizona,
Yeah.
nonpartisan activity intended to encourage voter registration and turnout. So, one of the things that I think that lawyers, operations folks, and field folks are gonna want to work through themselves first, or ask us. But I think that they'll want to pay some attention to this. Is what kinds of ways do they want to make sure that they can show that their voter registration and turnout activities are nonpartisan? What are the ways they're going to do that? And one of the things that we've said, and this may be a cause for consternation among folks in and of itself, but one of the things that the commissioners, we meet every month, and anybody's welcome to attend, and I urge anyone who wants to do so. We have had some, we have very long serving commissioners who are really active parts of their communities. Mark Kimball has been our chairman now for a couple of years, and I'm sure many of you know him. We have we've said, we're not, as a commission and staff, we're not campaigners. We don't run campaigns. And so, our focus for this, especially in this initial year, will be and will be around trying to make sure folks get in compliance and address those kind of questions, rather than going through, rather than trying to take sort of an enforcement first approach. And part of the reason to do that is because, I think, and I can only speak for the commissioners to a certain degree, but from my perspective, at a minimum, we want to see we need some to see some activity happen where folks can show us where we're talking about what folks are actually doing, how they're being impacted by this, positive or negative, and in terms of their ability to engage in their First Amendment activity. And then, and are the voters who voted for this still getting what they need under the act in terms of disclosure, right? How do we find that? And those are things that if we start sort of trying to throw them out in the abstract, is, they're tough to do. Because at the end of the day, the one thing I'll say, yes, that activity definition, is one that is irksome to folks who are in the field, but it's also very fact specific, and so there are pros and cons to kind of a fact specific analysis in that context. The pros of a fact specific analysis should be, if you have an agency, which we like to think we are, that wants to consider all the facts and circumstances of something, then you're not going to have theoretically just a bunch of sort of cowboy-esque enforcement activity. I mean, that's not our goal. It's definitely not our goal. The negatives of a fact-specific law like this are, it's a little harder for me in some circumstances to say, yes, that's definitely where the line is on that per se, right? And I think for those of you who have worked or have written your own literature or sent your literature to a lawyer or some other compliance person for review, just on the disclaimer, right? How fact specific the questions you get back from in that interaction are, right? So that's in that sense, the analysis will be much the same. It may have it may touch a little bit different activities than it did before. But that, we'll kind of see how that plays out. I think it's particularly, a cultural shift for folks who who come of age as political operatives and consultants and other things post Citizens United and post Arizona's 2016 law that reformed our campaign finance code. The combination of those two events, one in 2012 and one in 2016, was to literally say in Arizona, if you're a 501c4 who has filed the preliminary paperwork with the IRS, not just the notice, but the actual 1023 or 1024 form, you're not a political committee. And in fact, it prohibited enforcement officers from looking past that paper evidence.
Yeah.
So if you start, so think about this. The number of people who started in politics since 2016 is like a lot. So some of what I'm saying will maybe be more familiar to people who worked in campaign finance or operations or compliance from basically 1986 in Arizona until 2016. But if you're coming up in 2016, a lot of this is not going to be as familiar to you. And that's something that's still a bridge that I haven't quite figured out how to bridge. I haven't figured out how to cross effectively. Because that does seem to be a real significant thing. And then Michael, just to get back to your earlier question, the link for our rulemaking page, which has the AOs and our rules, is there. But a couple of questions we've already answered are: gathering petition signatures for an initiative alone is not campaign media spending. So and then the other question we got and we heard some consternation around was, does this mean that Clean Elections can come into my office and look at every PowerPoint that I ever put together, every campaign plan I ever planned, and all that kind of stuff? The answer to that is no. And it's especially true that and we said that the commission said that in an opinion that said that research, polling data, analytics done for internal use are not campaign media spending. And then and the act is really looking at some form, for the most part, of public activity that is to influence the votes of the voters. That's the core essence of the act. So I was gonna go to the next slide if that's okay with everybody.
Sure.
Okay. So a couple things. Filing. To my knowledge, no one has filed a Prop 211 report yet. And those of you who've worked with Clean Elections in the past, for about the past 10 years, we have not had very much access to the campaign finance website, which it's probably better that way, I suppose. But it does mean that if you have questions about filing, physically filing, setting up an account, we really have to direct those questions to the Secretary's office, because they under this act, just like the regular campaign finance code, they own the campaign finance filing system, which is, I think, currently called Beacon or Spotlight. I think Beacon is the filing and Spotlight is the public facing website. And then for illustrative purposes, this is what's in the report. This is way too small a font for anyone to read, I understand.
Yeah.
but what's in this that is, and I should have put this in a slide, I failed to include it, because the city of Phoenix and the city of Tempe, they have dark money ordinances that are very similar to this, but the kind of information we're talking about, the identity of the person who's in charge of the money, the identity of other entities they control. Because one of the things that the act says, and this is a little different potentially, because I honestly don't know how most action funds, for example, organize themselves. But if one action fund is actually controlled by a 501c3 that's part of a consortium of 501c3s that controls 5 501c4s, you're not going to be able to parse those out. It's going to lump those together, and it's doing that to avoid what the act refers to, and it comes out of white collar crime, structuring of transactions. So the act is trying to say, if you hit that 50,000, the greater than 50,000 threshold, we don't want you to be able to, spend out of, ABC fund and DEF fund that are all controlled by, by the same control group, and somehow avoid the disclosures. Obviously, there's a lot of contact information about who's custodian of records, and then we start getting into the original monies, question. And there you see that this is one of the reasons I wanted to highlight this, more than $5,000 of traceable monies or in-kind contributions. So you've got to give more than $5,000 to have your name on a campaign finance report that's required under Prop 211.
Yeah.
And that's we think, and what we said in the papers defending this case, because there's a number of different lawsuits I'll talk about in a little bit, but challenging this, but we think $5,000. We're not trying to get the $200 donor. We're not trying to get everybody and their brother, or I shouldn't say we're trying to get anybody, but the voters weren't interested in that. They're interested in people who have, relatively serious skin in the political game. You probably are, and especially anyone like Bob who's run clean before, if you're getting $5,000 from somebody, chances are you're not getting that person's last $5,000. But when you're running clean, and this is why, from my perspective, the clean financing program is the heart and soul of this whole operation. But because getting $5 from somebody, that's hard work. Because that may very well be a $5 they've accounted for, right? I mean, that's how the world is in reality. So that's sort of, and then we're looking at, we also want to know about the disbursements. So disbursements of 10,000 or more, those are going to get reported. I wanted to sort of hit some miscellaneous. There are actually, there's a ton of other stuff in here that gets into in the act, I should say, that gets into a number of other definitions and I want to, I don't want to get, I don't know that I can capture everything. But as you're going through it yourselves or whatever, if you have questions, just shoot them our way. We'll try to answer them. But once you've hit, so you have 5 days after you hit your threshold to file your initial report, and then periodically thereafter, if you hit additional thresholds, you'll file additional reports. That should be familiar to most folks who, on the FEC side, are working with electioneering communication. On the Arizona campaign finance side, are familiar with what we call 16926H reports, which are trigger reports, or the clean elections trigger reports. We mentioned there, just going back to the conversation we had earlier with Chris, PACs and parties have got to look at that language and make a determination on whether or not they're covered persons, because toward the close of the election, PACs are going to have an additional periodic report that they may have to file, depending upon whether or not they're covered persons. If they're not, they're not. But if they are, they have some additional reporting. Disclaimers. There is a rule we've passed that's on our website about disclaimers that is different from the disclaimer law that is in, I think it's 16925. Okay, so to get into, just to nerd out here about this for a minute, in 2016, when they rewrote the campaign finance code, they created this very strange dichotomy that said that if you're a PAC, you have to identify your top 3 PAC donors. But if you're a 501c4, you just have to say you're the 501c4, right? So if you get a mailer from a PAC, and this particularly affects, in my experience, if you are, because most unions operate with separate segregated funds, right? So the union is probably going to have, to disclose these, the top 3 donors because it's a PAC, whereas a corporate 501c4 doesn't have to disclose that. This says for covered persons, everybody's got to disclose at a minimum their top 3 donors, and the commission through rule has said the minimum will be the maximum. We're going to require you to disclose your top 3 donors. Someone can comply with 16925 by doing the Prop 211 disclaimer if they want to, but what I think will probably end up happening is that PACs and 501c4s up to the threshold will use one disclaimer, and then they'll switch once they get to the the $25,000 or $50,000 mark. That's what I expect will happen. I guess it kind of depends how time sensitive their print runs are and how hard it is to switch out the art cards and those kinds of things. But that might be too obscure even for this crowd. but I think that those of you who have, again, I mean, this is the thing that when I talk to my friends and colleagues who work in compliance and operations, I mean, these are the things that really are the nuts and bolts of day-to-day, campaign compliance. There is there's an enforcement provision that allows the commission to do enforcements if there are complaints. And then there's also a local savings clause. And what that says is if a city or a county wants to have a more restrictive, I shouldn't say more restrictive, a more disclosure-oriented act, they can have that. And that's designed because if you all recall when Tempe and I can't remember, Michael, quite honestly, what Tucson ended up doing on this issue, because I thought y'all might have an ordinance around that allowing this, but maybe not. But anyways, Tempe and Phoenix have these have ordinances that are very similar to Prop 211, and there was one of these they call them 1487 letters, where a legislator writes to the AG and says, "Isn't this wrong?" Right. So Attorney General Brnovich had some issues with the Tempe and Phoenix ordinances. The Prop 211 attempts, by its terms, seeks to release those cities and towns from those kinds of restrictions that the legislatures had sought to put in place during the during the anti-disclosure period.
I would just like to add, I really love the presentation because I'm even learning stuff, but I think it depends on the audience. And I think it's really important to know the audience, because if you're talking to people that have had no clue of this and to get the clearly to understand it, I know there's a lot of detail that you need to know. It might need to be boiled down a little for certain audiences. That's all. And also I had a question in the chat. Because when we were marketing this, I was the regional coordinator for Dark Money.
Right.
And, it was not so much geared to that. The gist of it was not geared towards political action committees or 501c4s. It was more 501c3s who were not even affiliated with political stuff and were acting as pass-throughs. Like I could name you some, I won't, but so yeah, tell me what your general impression. Yeah, go ahead.
Yeah, no, I think that's right, and I think that that's a really good observation. I think that, and I think that's probably a place I could either slide in an additional slide if I was doing this again, or talk about it a little bit differently. That's right. I mean, the ultimate goal here is to get to the original source of dollars, notwithstanding all the pass-throughs that may exist. From an administrative perspective, that's that really gets into, I mean, the transactions around that are a little bit, they're a little complex in the sense that it requires the end spender to go to the donor and say, where did you get the money? And then the donor has to provide that information back. And through that, and eventually, theoretically, through that process, we should be able to learn who the original source of funds is. Certainly, that original source of funds, when we interact with folks who maybe wish this hadn't passed, and that's a nonpartisan position, right? I mean, at this point, being pro 211 or anti 211 tells you nothing about someone's political party at this juncture, at least as an administrator. And maybe in casual conversation may be different, but our experience is, we're dealing with attorneys and folks who have clients who have a vested interest in all of these things, right? So no, that's absolutely right, Chris. I didn't spend as much time on that. It is true that the idea here is that you ought not, at a minimum, be able to show up in Arizona, not tell anybody who you are, drop a bunch of money in an election, and run away. That should not be happening here after that. 501c3s, if I can just, because it's a kind of an interesting issue. 501c3s are interesting because, and if y'all know this, forgive me, but because a lot of you probably do, but they can lobby up to ballpark 20% of their a budget, under the IRS's guidance. And initiatives, referendums are lobbying by IRS judgment. So while a 501c3 can't participate, at least theoretically, in a candidate election on the IE side, they can, in fact, you could run prior to Prop 211, you could run an entire initiative campaign out of a 501c3, and the only obligation you'd have to report in Arizona would be the spending on advertising above $1,000, which would just tell us that some such and such 501c3 spent the money they spent, and that's all you would have to disclose. So for the initiative and referendum world, this is a significant change, even beyond what the 501c4 world, who can dabble in candidate campaigns, and some might say more than dabble. It's a very significant change, and I think that that's something, as you go out and talk to folks and you hear from your colleagues who are working on initiative campaigns, I think that's something that folks who fund those campaigns are concerned about. That said, I mean, my point of view on it is that if somebody's campaigning for a particular tax incentive or whatever. I mean, let me put it this way. I wouldn't have this job and I wouldn't have been doing it if I didn't think that, for the most part, it's better to have the information than not have the information. I think it's important. But definitely you'll hear this. I guess what I'm trying to get at is that as this becomes a real thing, and as this has become a real thing, it doesn't while it satisfies equal protection better, in my view, than the pre-existing law, because all speakers theoretically are having to disclose at the same level, regardless of whether or not they filled out a form to be a 501c4 or they're a separate segregated fund of a union, right? That playing field is now identical, essentially. But if you're the incumbent 501c3, your world just changed, right? So that's sort of a lot of the what we're able to gather on the as administrators, and all I think the commissioners are and my fellow staff members are really, we definitely feel commitment, and the commissioners for whom I work, we have expended a considerable amount of energy and time defending disclosure at our legislature during times when disclosure was incredibly unpopular among the majority of legislators. There, and not to pat the commissioners on the back too much, but there were times at which the Clean Elections Commission was the only thing in state government that was in favor of any kind of campaign finance laws at all. That time has changed, so we are no longer in that same position. But we are all invested in the idea that the public does in fact have this right to know. That said, the experience the commissioners have had in serving as long as they've had, and we'll get new commissioners I'm sure within the next few months because of changeover administration, but the agency itself has tried to maintain that commitment and also be conscious of the constitutional boundaries. And so when I talk about this, I try to talk about it a little bit differently than former Attorney General Goddard would, because his point of view on it and mine, we may agree on some things, but his advocacy for this has been very good, and obviously, and I think everybody he's really nationally recognized on this now in many ways that when he started he was not. He's really done that, but he can say and speak to the intent of the act with with a kind of with a freedom that I don't feel like I have, because I need to make sure that everybody understands we have to operate within a constitutional framework, and we want, and that's a real one. I mean, whether or not we agree that that the money that facilitates political advertising is the essence of speech or not. In fact, that's the law. So that's sort of, we're trying to do all those things at once. In other words, try to say, here's the philosophy, we agree with the philosophy, but the philosophy in application is going to be something that you have to be judicious about applying, and you have to treat the regulated community as fairly as you treat the voters who put in place this regime. So that was a little too speechy, probably, but anybody else got questions on 211, or do you want to hear a little more about the other stuff, or what do you want to do?
Yeah, we can move on.
Okay.
I think you covered the 211 pretty well, and I think we're going to get probably more clarification after the 24 election cycle, and we get more testing.
And I would keep your eye on the advisory opinion request, because I mean, I really think that that's where right now we're in the best position to try to clarify things where they can be clarified. The other thing I'll say before we move on, I also should mention, the commission has been sued in federal court by Americans for Prosperity on First Amendment grounds, in state court by the legislative leadership on an argument that the Prop 211 violates the separation of powers and some other constitutional doctrines along those lines, by the Center for Arizona Policy and the Arizona Free Enterprise Club under state constitutional grounds. So those are the cases that just exist as of now. The legislative leadership is currently petitioning to have their appeal for the denial of their preliminary injunction in Superior Court taken directly by the state Supreme Court, rather than stopping at the Court of Appeals. So the other thing that's not quite settled is, will there be, what will the courts ultimately do? I am confident personally that the law is constitutional, but that's something also to keep your eye on, as we move ahead here too. And I suspect that, I have no way to predict, and what will happen with any of that stuff. But we know at the U.S. Supreme Court that most things campaign finance related are just treated with skepticism. So that's just the reality. I did want to talk a little bit about voter education. I just, wanted to mention, these are the latest stats from the Secretary of State on voter registration. Where we have 4.1 million registered voters in Arizona. And we're still in this sort of strange universe of, where, close to having no party preference be the plurality party. And apparently there are 25,000 no labeled party members somewhere. Coming up real quick, just in case, just so you, and I know you all know this, but March 19th is the big PPE, which we are going to have no matter what. And, but remember, when you're talking to your friends who are independents, they can't vote in this primary. It's not a primary even, it's a special type of election. And please don't come and vote as an independent, because you just aren't, the law is what it is. And it's not the election official's fault. It's not the county recorder's fault. It's not the board of supervisors' fault. It's not the election director's fault. It's a legislative decision. July 30th is our primary. I suspect some of you may have actually known when the primary was prior to the change, but maybe many people didn't. That we are at July 30th primary, and that's just for this year, because the legislature wasn't able to conclude what the primary date should be going forward. But that was a successful, we thought, the commissioner and thought, endeavor by the governor to lead the resolution of those issues. And then November 5th is our general election. As I'm talking about voter education, I wanted to highlight something we're very proud of. As you may recall, Governor Hobbs convened a bipartisan elections task force during her first year in office, and it made a number of recommendations. Some of them, some of them about making sure that our elections continue to be safe and secure and accurate. But one of the things they recommended was that CEC continue to develop its web presence to become a statewide one-stop shop for voters, which we are very excited about this recognition, and we're working on now the relaunch of our website along those lines. I think that's going to be particularly important to Arizonans who live in rural parts of the state, because those county recorders and county election departments just don't have the same resources that a Maricopa County or a Pima County has on the web front.
So these voter resources are going to be at the CCEC website, or are you going to launch a new URL for that?
No, we're going to stick with azcleanelections.gov. There's some discussion in election administration circles about what you should use. The EAC, which is the Election Assistance Commission at the federal level, and CISA, which is the Cyber Infrastructure Security Agency, I think that's what that stands for. They both really recommend .gov, but .vote has been popular with some election officials. We think we're just to stick with what we have. If only because partially, frankly, if someone actually already has a website where the links are pointing at it, I wouldn't want to break all those links just to break them.
Yeah.
I mean, most of them are probably going to break eventually, just because that's how the internet works. But I want to mention real quick our debates. Some of you may have seen that we a couple months ago announced a partnership through the Arizona Media Association to try to bring statewide and federal debates to more broadcasters, radio stations, and newspapers. So that will be a program that we hope to continue to feature the U.S. Senate, which we've done since 2018. We are going to have congressional, we hope, and we'll also, at a minimum, have Corporation Commission. That partnership, we hope, will facilitate more people having more access to the debates. And then we will continue our Zoom series, which we've tried to make sure is increasingly moderated by local journalists. We do our voter education guide, which will be hitting your doorstep around the beginning of July. We are, as far as I know, this may have changed, but I don't think it is, the only state agency that's pamphlet goes out in both English and Spanish. You don't have to request Spanish. We do an indigenous languages translation of Navajo, Apache, at a minimum, and I think we may have added another language. I think we may have added Hopi, but I'm not sure. We do American Sign Language and audio versions. Our goal with that resource is, because we have the resources to do it, is to try to make sure that with that voter education guide, which people seem to recognize because it comes to your doorstep and it says Clean Elections on it, and it's got the candidate bios in it. But really, what we want that document to be is the thing that anybody in Arizona with any kind of access issue, with any kind of language issue, without a barrier, can pick up or log on to see, in the case of American Sign Language videos, and have as much information as anybody else. And they can know how to have their vote counted. They can know who's on their ballot. They can know where to find more information to help them. And that's really, I mean, to me, the Clean Financing Program obviously has been part of our, but the voter education guide, it seems prosaic, right? You just send out a booklet. I mean, what's the big deal? To me, it's actually a huge deal, because if you take that away, especially in view of the media landscape we have now and how difficult it is to find accurate information conveniently, right? Because just going on Google and Googling is not necessarily going to get you where you want to go, and before you even start on Facebook. So I think that delivering it in paper to most folks, really is a public good. And then we're going to continue.
On the same page is important.
What's that?
Having everybody basically see the same page is important.
That's how we feel about it, for sure. Okay, I wanted to talk a little bit about the late lamented clean funding program. Um, These are the important candidate dates coming up. The filing period for nomination petitions is open now. You saw Congressman Gallego filed for Senate the other day. I think he might have been one of the first people to file. The deadline for filing nomination petitions is the beginning of next month. The last day to collect qualifying contributions is going to be the 23rd. It's a week earlier than it was. And then primary election day is the 30th. These are the current amounts. Obviously, not all of these races are this year. This is still, and the last time I spoke with you all, there's still still tough to make the case, I think, to candidates, although it should be easier than it is, that, in some cases, you're not going to do better than clean elections. Your consultant may be saying to you, you need to do better than clean elections in terms of your funding. But the fact is, you very well may not be able to. And there is a real bird in the hand quality to clean elections that I think gets overlooked. The other thing that gets overlooked quite a bit by both parties is, and I would say this to both parties, is the fact that the coordinated party expenditure provisions of Title 16 apply to clean elections candidates also. So what that means is that because it's not a direct contribution, right? So it doesn't implicate the corruption values that the clean elections program is fighting against, but it does allow the party to have more interaction with its nominees. So after the nomination, than was permitted, when clean elections started. The funding that is being received by candidates is still 1/3 what it would be if the legislature had replaced our funding formula after the 2011 Free Enterprise Club versus Clean Elections case, instead of just eliminating 2/3 of the fund. And I've been saying this for a decade of my life. It doesn't necessarily make a difference, but to change anything. But it's worth reiterating, I think, time and again, that neither the voters nor the candidates are getting the benefit of the bargain they struck in 1998 right now under the Clean Elections Act because of legislative choices.
Yeah.
This is the summary on the seed money, which many of you are familiar with. The seed money individual contribution is now up to $2010 or $210 rather, based on inflation. And I think that may be it. So that's kind of our update on what we're up to.
Well, that was lovely, Tom. Thank you so much. I appreciate that. If you want to take down your slide, we'll
Sure.
close out this this hour, it looks like. And
so, anybody questions?
Just a thank you, Tom.
yeah, so much. Yeah.
And
So,
yeah,
No.
go ahead.
I just having done so much of this, grabbing signatures for 211 was really about condensing it down to like the basics, right? So we were always talking about how, those big political ads you see, we don't always know where the money's come from.
Right.
And that was basically the whole kind of spiel. And people say, well, we don't want that, but they don't really understand the underlying legal and all the other issues. I just want them to know that something's being done and that there could be something they can do to support you or help in the cause. Right. So, yeah.
Well, I appreciate that, and I do think it's. I mean, I will say this. I mean, I wasn't involved in the drafting of this at all, but I know the people who were, and as a legal matter, I think it's. I really think it's complex, but it's pretty clear. There's not a lot of real. There's nothing that I would say is truly vague. I think the harder part when you're in the practitioner community of whatever, whether you're a legal practitioner, or an operations for whatever, it really is I don't think people understood, at least the people that we have, the people we've heard from, and like I said, I would love to hear from more folks, especially if you know a treasurer who's got questions, have them call me. We'll do whatever we need to do to walk them through it, at least this much, if not more. But I think that part of it is I don't think people who are inside really work on this stuff appreciated how much the people had come to have expectations around the way business had been done, A, and B, I think from a partisan, observing Democrats maybe versus Republicans. I mean, from I'm an independent and I've worked for an independent agency now for 10 years, but so I deal with both parties. Republicans have tended to be ideologically, not all, but mostly been ideologically opposed to these kinds of laws. Democrats, not so much, but it's quite evident that over the course of the past decade, since the 2016 law that reformed by some people's lights campaign finance, the Democratic Party did a very good job of operating within that new regime. That regime was written by Republican legislators and the then Republican Secretary of State to empower Republican 501c4s to win Republican victories. That was fairly openly discussed at the legislature at the time. The Democratic caucus opposed it by and large, and I think almost every Democrat voted against it. And some of those Democrats even sued, saying it violated the Voter Protection Act because of the Clean Elections Act. But in experience, I think was that in fact no, the Democratic Party has done well understanding how the law worked and the advantages of it. So anytime you change something like that, it's going to have some consequences that, whether they're intended or not, they are real. And so trying to work through this in a way that's judicious and without breaking faith with the voters and what they wanted is something that the commissioners for whom I work, I think care a lot about. I mean, we really had some. I mean, our commissioners now, I mean, they're all holdovers, and we've had one commissioner on for about 10 years. There was an AG opinion recently about how they should get replaced, and that'll probably happen. I don't have it. I'm the last person who will know, but it will happen. But I think that for this first year at least, and the past several years, I've been really lucky in my job to have 5 commissioners who continued to, notwithstanding the fact their terms were up, continue to come, continue to be invested. I don't mean to keep you on the Zoom too long, but one of the things that our commissioners believe, and we believe as staff members, is that one of the things we should be doing as the Clean Elections Commission is trying to create a lasting institution. Because one of the things in Arizona that is you see over and over again is that as still a young state at 110 years old, we don't have strong institutions. Our institutions are put under enormous pressure in ways that I'm not sure other states really are. And part of that's because of the competitive political environment. There's other aspects to it as well. People move in and out very much, all these things. So it's been the consistency and the commitment to just continuing to show up and whether it's our debates or the clean program, even when it's not going great. It's important, I think, to all the commissioners to be there, because we need those bulwarks against the impermanence of everything else.
Great
Right.
input. Thank you.
Thanks for joining us, Tom. I appreciate you staying late and
anytime.
with this. I'll send you a copy of this along with an AI transcript that you can query that is pretty cool. It's called Otter, and that should be fun for you to play with, so you can see how that works.
Yeah.
It's a joy to work with. And so we'll end it there.
All right.
Thank you. Thank you, Michael.
You bet.
Hey everybody, it's Senator Mark Kelly. As all of you know, Arizona Democrats have had a lot of important wins over the last few years. We won 2 U.S. Senate races, and we delivered Arizona's electoral votes to President Biden and Vice President Harris. We elected Governor Katie Hobbs, Secretary of State Adrian Fontes, and Attorney General Chris Mays. Now, those elections were close, and our victories mattered. Arizona Democrats from the federal to the local level have delivered real results for our state on critical issues like combating climate change, lowering prescription drug costs, protecting the right to vote, and preventing more restrictions on abortion access. The Democrats of Greater Tucson offers the opportunity to hear from elected officials and candidates about that important work and the issues that matter to them. That information will be invaluable as Arizonans head to the polls. So this election cycle, whether you're signing up to knock doors, make phone calls, or joining the Democrats of Greater Tucson to hear from and speak to Democrats in our area, please know that your voice matters and we need you on this team. Thank you.